Thank you, Professor Kamek. It's a great privilege and pleasure to welcome members of the extended Pepperdine University School of Law family, friends, students, members of the faculty. Our university president is here. We're delighted that each and every one of you has chosen to spend the afternoon with us for a very important topic. The nation has a new Chief Justice of the United States. John Glover Roberts, Jr. is highly energetic. It is a new day at the Supreme Court, and we now have the benefit of one full term, although the term is officially still on. The court stands in summer recess and will return in September to review the summer cert list, but then, of course, comes the first Monday in October, and we all look eagerly forward to that. It will be the first full term with the two new members of the court, the Chief Justice of the United States, Chief Justice Roberts, and Justice Sam Alito. We have been through confirmation hearings, and you've had the benefit of some excerpts on the screen during the moments before we officially convened. So let me thank you for coming. We at Pepperdine pride ourselves on our hospitality, and so by all means, let us know if there's any way we can make your visit more congenial. It's my great privilege to briefly introduce, but you have elaborate introductions before you or descriptions of this very distinguished panel with one singular exception, your humble servant. We're very pleased to have on the panel and speaking early on after Professor Kamek, whom I'll introduce momentarily, gives us a summary and overview. But we're very honored to have for the second year at Pepperdine University School of Law, self-made professor of law at Yale, Akhil Reed Amar. Would you join me in saying thanks and welcome to Professor Amar, whose course on America's Constitution is already becoming the stuff of legend, and rightly so, around our law school. We're so thankful to have back in our community and back in Southern California, Erwin Chemerinsky. Would you join me in welcoming Professor Chemerinsky, who as you know, spent so many years and to good effect at the University of Southern California, and now holds the Alston and Byrd Professorship at Duke University School of Law. So Erwin, we're delighted to welcome you back to Southern California. Speaking of the University of Southern California, we're very thankful to have the Vice Provost for Academic Affairs, although she's had already another promotion since we produced this bulletin. Would you welcome Elizabeth M Garrett. A prolific scholar and commentator and a senior officer now at the University of Southern California. I will more properly introduce Professor Kamek, but we're also delighted to welcome as interlocutors three very distinguished members of the press. Join me in welcoming Marcia Coyle, the Washington Bureau Chief and U.S. Supreme Court Correspondent for the National Law Journal. Those of us who watch the court read her work with interest and with profit as she has covered the court for Marcia, who's counting almost 20 years. Please welcome Jenna Holland, the U.S. Supreme Court Correspondent for the Associated Press. Jenna joined the Supreme Court beat 5 years ago, and her work is read perhaps as frequently as anyone's by virtue of the ubiquity of Associated Press. So Jenna, thank you so much for being with us. By no means least, the very distinguished Supreme Court correspondent for the Los Angeles Times and observer of the court, author of books. Please welcome David Savage. The audience may not be able to see the faces I will ask my faculty colleagues actually to stand so that the audience can recognize you, beginning with our beloved Bernie James, Professor Bernard James, Professor of Law at Pepperdine University, and a member of our faculty since 1984. And speaking of legends, please welcome James Jim McGoldrick, an institution at the Pepperdine Law School. Robert Pushaw is a former student and proudly claims to be the student of Professor Akhil Amar at the Yale Law School. Please welcome our own James Wilson Professor of Law, Robert Pushaw. Each of our three will serve as faculty respondents. It's now my great privilege, and it's a great blessing here at Pepperdine to have one of the nation's most eminent academic scholars and students of the Supreme Court of the United States, a person of great theoretical power, but also of enormous practical experience in public service. Would you please welcome, under the auspices of the Caruso Family Chair at Pepperdine University School of Law, our beloved Doug Kamick.
Thank you very much. It's a pleasure to have you all here in this wonderful place. We did this a few years ago, and we decided that finally the Supreme Court had given us excuse to do it again. And the October term was indeed quite a term, less perhaps for any singular case, but certainly for the landmark passages that took place on the court. A new Chief Justice for the first time in close to 20 years, an addition for an Associate Justice and the first time in over a decade. Most of our day will be spent looking at the substantive work of the court. Criminal justice, civil rights, law and politics, the separation of powers, the business and commerce cases. But we will also have a second panel, since we have wonderfully distinguished journalists with us as well, that will evaluate how well the confirmation proceeding went, what questions were asked, whether any were answered, and how the process might be improved, if at all, and what might be said about the public coverage of that event as well. I am absolutely delighted that the scholars and journalists that we asked to be with us accepted so readily. The fact that they did put me in mind of actually a story that John Roberts told when he visited Southern California a few months back. He related as to how, when he was clerking for the late Chief Justice Rehnquist, who was by nature somewhat timid and reticent and hesitant to accept invitations, that he really had two letters that he relied upon, one for the current year and one for the following. The current year said, "Thank you, I appreciate the invitation. I cannot accept. You can appreciate how busy my schedule is." The second for the year out said, "Thank you, I appreciate the invitation. I cannot accept at this early date." I can tell you that we received none of that hesitation from any of the members who are here with us today, and we are very grateful. The beginning of the Roberts Court really starts with an ending, the retirement of the legendary, groundbreaking, ever-balancing Sandra Day O'Connor. Sandra O'Connor, of course, had a role on the court that was quite prolific and indeed often described as pivotal. Her vote was often needed to form a majority on the court. In fact, if my counting is correct, she left the court this term having joined every single majority of the 20-plus cases that she participated in before her retirement. It may come as a surprise to some of you that the person that she agreed with the most in terms of voting affinity was William Rehnquist. She agreed with the late Chief Justice 81.3% of the time, which just goes to show you that Stanford blood is thicker than vote trading. Her next strongest affinity was with Anthony Kennedy, and of course the two of them have been described as swingers. Justice O'Connor's importance on the court perhaps was confirmed even further by the fact that it took 3 nominees to replace her. Of course, John Roberts was initially nominated for her position and then redirected to the center seat when Justice Rehnquist died. Then there was Harriet Miers, which didn't work out, and then finally and ultimately Samuel Alito, who is the new Associate Justice. Statistically, there's been some very fine work done on the term by a number of people. Tom Goldstein, who's a practitioner at Aiken Gump, the American Bar Association, does some good statistical summaries of the term, which they publish in ABA Preview. The folks at Georgetown do a summary of the court. But there's also some very interesting work that I'd like to point out to you by Professor Lori Ringhand of the University of Kentucky. She takes a good deal of this other statistical work and arrives at the following conclusions that I want to share with you. That the ideological direction of the Roberts Court is, of course, conservative. That's not a headline. But what is interesting is that it is not dramatically so. That Chief Justice Roberts' efforts to bring more unity to the court was the more salient aspect of the direction of the court this year rather than his conservative direction. The fact that he sought this unity is identified by Professor Ringhand and others in a number of different ways, including the fact that he was personally reluctant to write separate or concurring or dissenting opinions. In fact, by my count, he in fact issued only 4 concurrences or dissents. In the LULAC case, which Professor Garrett will talk about, in the Katz case, an 11th Amendment sovereign immunity decision, in the House decision, which allowed for the introduction of new DNA evidence, and in Gonzalez versus Oregon, which struck down or invalidated former Attorney General Ashcroft's regulations with regard to assisted suicide in Oregon. The second point that is clearly identifiable with respect to the Roberts Court is that there is a high affinity between John Roberts and Samuel Alito. Both of them are focused in their writing on very specific, restrained aspects of the court's jurisprudence, and they may have this in common because of their common background, or they may just be sticking together in safety against those that they encountered when they arrived at the court. The third thing is, of course, something that has been noted by many public writers, and that is that Justice Kennedy has a new role on the court. In fact, a number of public writers indicated that it is the Kennedy Court rather than the Roberts Court. I think there is a plausible supposition for that, but I have to put on my glasses to see why that is. I also think it can be qualified in the following respect, and that is Justice Kennedy has a tendency to write at a very high level of theory. That's polite. And as a result, his writing is often aimed at producing an outcome, but not necessarily a discernible or long-standing rationale. He is, in this respect, a bit of Garfinkel without Simon. It's a tune, but you don't quite know what the lyric is. And that actually is a substantive observation, because one of the qualities, in my judgment, that Sandra O'Connor brought to the court was that she knew the direction she wanted to take the court in, and in order to win her vote, she would rather carefully and strategically wring concessions from those who were circulating opinions. Insofar as the intellectual qualities of Justice Kennedy are to be somewhat more indeterminate, to be open-minded, of course, but also to be exploring in a more general way his perspective, his bargaining capacity seems to me to be somewhat less. And therefore, it runs into another force on the Roberts Court. And I'm going to call this force the Roberts Revolution in favor of judicial restraint. More on that in a minute. We, of course, in this year saw the legacy of William Rehnquist also result in somewhat of a diminution. It was, in fact, suffering some blows even as the late chief was quite ill. We associate the Rehnquist legacy with greater accommodation of religious belief. But in the final term in which he served, you'll remember that 10 commandments were allowed in one place, but not another. And so to some degree, religious accommodation became a more muddled subject. 5 commandments are allowed everywhere. New exceptions were crafted with respect to the application of 11th Amendment sovereign immunity. This was a doctrine very close and dear to the heart of the late Chief Justice, but in the last term that he served and in this most previous Roberts term, the 11th Amendment has been pulled back somewhat as a protection of sovereign immunity. The late Chief Justice's efforts to limit the commerce power might be said to have gone up in a puff of medical marijuana, and the constitutional protection of private property also subsided. In the area of eminent domain, one remembers the very controversial Kelo case, and a less remembered opinion was Lingle versus Chevron, where the standard of review for land use cases became far more deferential and approving of regulation. So insofar as the Chief Justice was watching his own legacy to some degree erode even as he was holding on to life, one can speculate that the late Chief might have had some skepticism about his own colleagues.
One thing I found frustrating, and I dare say every junior justice has found frustrating, is that after 8 people have spoken before you do, there aren't really 9 points of view about a case, and you are often simply left to say you agree with so-and-so, and even if you have kind of an original idea, speaking ninth, no one else has had a chance to hear it, and often you have a feeling that it isn't given the attention that it deserves.
Do you ever think when you're sitting there and you're discussing the cases and you hear one of you outline his or her position that you think, gee whiz, I mean, that's really a lot of nonsense?
I've thought that about all 8 of my colleagues at one time or another, I think.
Each of us has like a...
William Rehnquist served on the Supreme Court of the United States for 33 years. He served as Chief Justice for 19 of them. May he rest in peace. So who are the new members? John Roberts is a former Rehnquist clerk, and he might be assumed to be rather straightforwardly a clone of the late Chief Justice. Is that the case? This is known as a theatrical pause.
Someone in the mold of a Rehnquist. Is that a fair assessment?
Well, you know, I admire the late Chief Justice very much, and but I will have to insist that I will be my own man, and I hesitate to be put in anybody's mold. And I would certainly approach the cases according to the judicial philosophy that I have developed over the years. In many respects, it's similar to his in its recognition, I think, of the limited role that judges should have, an appropriate modesty and humility, a recognition that
The idea of a dramatic departure under your watch from the Rehnquist era is probably not going to happen. Is that true?
given my view of the role of a judge, which focuses on the appropriate modesty and humility, the notion of dramatic departures is not one that I would hold out much hope for.
And he delivered. We had no dramatic departures. John Roberts was born in Buffalo, New York, but he grew up in Indiana, which makes him a Hoosier. Garrison Keillor, an authority of the Supreme Court, put it this way: Mr. Roberts has a good story. A boy grows up in Indiana, which is a disadvantage, but he overcomes it by hard work and clean, purposeful living. He learns how to excel without offending anybody, which is a great and good art, and he ascends the ivy-clad citadel of Harvard, and he rises through the ranks, managing editor of the Law Review, Supreme Court clerk, job at the White House. He plows forward. Political labels don't quite stick to him. Friends of various stripes have only good things to say about him. He is cool. Not only is he cool, but he has a splendid mind, and indeed he has a commitment to judicial humility. He explained his own commitment to judicial humility in terms of the national pastime.
Reinforces my...
He has a bit of a stutter, but he's working on it. Well, you know, please don't interrupt. You know that he described himself as an umpire and pointed out that no one ever goes to a baseball game to watch the umpire. It was his way of conveying in very accessible terms, and that is the way John Roberts writes opinions as well, that he was not about to displace the political branches, and he was going to exercise as much judicial humility as was appropriate. In this past term, a case of significance that I think is an exemplar of that humility is Daimler-Chrysler versus Cuneo. Daimler-Chrysler was an intriguing dormant commerce power case that challenged the investment tax credit that Ohio offered to firms locating within its state. The argument was that investment tax credits offered exclusively on that basis discriminated against interstate commerce. It was an issue that has confronted the European Union, and it's an issue that, in fact, was not clear what its resolution would be as a matter of merits in the context of the litigation. That issue was left unresolved, however, because John Roberts, writing for a unanimous court, emphasized the importance of a rigorously applied standard of justiciability, and in particular standing. He pointed out in more than a few pages that the tax credits could work in any one of a number of ways, none of which would lead to a particular or concrete injury suffered by the plaintiffs, and as a result, the most appropriate direction for the court to take was to stay its hand, to not issue an opinion on the merits, and allow state and local policymakers to be more important, he said, than Supreme Court justices. That, I think, is a fine example of the Chief Justice's humility. But beyond humility, there was also unanimity. John Roberts promised and delivered that he would encourage greater consensus and collegiality on the court. Unanimity indeed prevailed. 37.7% of the argued cases were decided unanimously. An additional 12% of the submitted cases were also decided in a manner where the judges in their entirety concurred in the outcome, leading to the remarkable percentage of roughly 49% of the cases being decided without dissent. That's half of the court's docket. It is far higher than the previous term or any term in the previous 10 years. And if this evidence of unanimity and collegiality was not sufficient, I offer you a couple of other measures. First of all, a significantly fewer number of 5-4 opinions, and the fact that there were fewer separate opinions altogether. In fact, 34 fewer separate opinions. Now, what's the cause of this happiness on the Supreme Court? In part, it's the conscious desire on the part of John Roberts to issue rulings on the narrowest possible ground. He said in a university speech that if it was not necessary to decide, it was not necessary to decide, and he wouldn't reach out for it. On smaller ground, the justices would be chummier. In addition, one can get the impression, though one is not admitted to the inter sanctum of the court, that the conference proceedings conducted by the justices are allowing a fuller discussion of the cases and interplay among the justices themselves. The late Chief Justice, William Rehnquist, prided himself on not having an interruption. He didn't want to have the justices debating the issues around the conference table. One gets the sense from John Roberts and what he has said publicly and what others have reported that, in fact, those discussions are more fulsome, suggesting that there is more agreement that is emerging as well. Here's a question for you. Is unanimity a good thing? One aspect of the unanimity is to have, presumably, more stable opinions. If super stare decisis means anything, it probably means something associated with a unanimous judgment of the Supreme Court. But if unanimity is also premised upon the narrowness of the ruling, is that an ethic of judicial restraint or merely an invitation to come back and talk some more? Many people have raised the proposition that, in fact, narrow rulings that produce unanimous outcomes, in fact, are reserving to the Supreme Court more power rather than giving it up. Beyond humility and unanimity, there is also the emphasis upon law. It has been pointed out that John Roberts likes to cite statutes. How odd. Cases. He, however, does not cite widely, and if at all, the secondary commentary of the Academy. So I'm taking up writing statutes rather than law review articles. But these are the ingredients of the Roberts restraint revolution: humility, unanimity, and precedent. To know John Roberts is to know Sam Alito, as I pointed out, because they agreed in over 90% of the cases in the past term. So what are some of the headlines from the past term that you will hear from our panels? First of all, you will hear, and I'm certain you've not heard this before, the president does not have a blank check. That statement is less revealing than not, and we'll explain why. Federal state cases largely went to the states, although there was some exception. The states were free to do mid-census redistricting. The states were free from Attorney General Gonzalez's interference with their program of assisted suicide. The states have more latitude, presumably perhaps for abortion regulation in light of the Ayat opinion that directs judges to issue the narrowest possible ruling on the topic of constitutionality. The states did not always win. As I mentioned earlier, the 11th Amendment was scaled back a bit, both in respect to the bankruptcy power and also with respect to Title II of the Americans with Disabilities Act. There were a number of speech and association claims brought before the court. These largely did not prevail. Law schools that did not want to talk to the military but wanted to accept federal money were told money and military go together, and there is, in fact, no either speech or association infringement that is associated with that. Those that want to raise issues of impropriety about procedures in the public workplace were told as whistleblowers that if they're talking about their job responsibilities, their talk is outside the protection of the First Amendment. The business community was treated rather well, though they're never entirely happy, and they complained that the rulings were less specific than not. The criminal justice fraternity noted that there was less solicitude for criminal defendants. We'll see if Professor Amar agrees with that in a moment, but there were a number of very important cases, including the Hudson case, in which the exclusionary rule was not applied in the context of a violation of the no-knock doctrine. So what about Justice Kennedy? Justice Kennedy was a switch hitter. Sometimes he went left, sometimes he went right, and my theory still is that he never is quite predictable, and to some degree, his emphasis or his impact on the court is limited by the desire of the Chief Justice and Associate Justice Alito to issue narrow jurisdictional rulings. Looking forward, there's a number of cases on the docket of some importance, including whether racial preferences will be extended to school systems in K through 12, whether the partial birth abortion ban will be upheld or invalidated, whether excessive punitive damages will be brought within the bounds of the previous State Farm ruling, whether the EPA will be told that they have an obligation to regulate greenhouse gases. All of these cases will be mentioned or discussed in the proceeding that follows. In sum, the Roberts and Alito Court is a court that has an affinity toward judicial restraint. It is a partnership that I think changes the previous paradigm on the court. It was commonplace to describe the court as divided liberal, swing vote, conservative. I think the new paradigm, in light of the work of Justice Roberts and Alito in the first term, is the liberal side of the court, primarily Justice Souter, Stevens, and Ginsburg, matched on the other side by Justices Scalia and Thomas, but in the center, a swing voter, Justice Kennedy, and then two justices, and possibly three, Roberts, Alito, and Breyer, who may have affinity on jurisdictional questions more often than not. Is this a good development? Is this realignment a positive thing? I would suggest it is, but more on this as we get to our panels. Let me tell you a bit about our process. We will have 5 main presentations. The presentations will be followed by questions from our Supreme Court journalists, and they will also be followed by your questions. We very much want you to participate in this event this afternoon, and there are cards that have been distributed on the tables, and if during the presentation you have a question for a particular speaker or for the panel in general, we would ask you to write it on that card and to signal one of the student runners who will be going back and forth on these stairways, collecting cards and delivering them to our faculty facilitators. Now, as our favorite visiting professor at Pepperdine, Akil Amar, takes the podium to discuss the criminal justice cases, it will be introduced by a few comments from Associate Justice Samuel Alito. Thank you very much.
Do you think it could ever be constitutional to admit evidence obtained by torture against an individual who is being charged with a crime?
Well, the Fifth Amendment prohibits compelled self-incrimination, and it's long been established that evidence that is obtained through torture is inadmissible in our courts. That's the governing principle.
So I take that answer to mean it could not be constitutional to admit evidence obtained by torture against individuals being charged with a crime.
In all the contexts that I'm familiar with, that would be the answer.
Thank you for that answer. I want to follow up on one question that Senator Leahy asked this morning about the constitutionality of executing an innocent person. He said that the Constitution, of course, is designed to prevent that. We all agree on that. But let's say that the trial was procedurally perfect and there were no legal or constitutional errors, but later evidence proves that the person convicted was unquestionably innocent. Does that person have a constitutional right not to be executed?
The person would first have to avail himself or herself of the procedures that Congress has specified for challenging convictions after they've become final. If this individual has been convicted and has gone through the whole process of direct appeal, either in the state system or in the federal system, then there are procedures. States have procedures for collateral attacks, and there are procedures under federal statutes for collateral attacks on federal convictions and on state convictions. And the person would have to go through the procedures that...
Enough on the procedure, more on the substance.
I wanted to hear the answer to that one. Maybe we'll get to it. So as Professor Kmek has said, I think, and Dean Starr before him, the big news of the last year is less this case or that one, but the change of personnel. Let's start with Justice Alito, since you heard a little bit more about Chief Justice Roberts. Justice Alito is a former prosecutor. He brings to the court not only more prosecutorial experience than any of the other members of this court, or actually the court in recent history, but perhaps more prosecutorial experience than any previous justice in U.S. Supreme Court history. How will that play out? What will it mean? Let's take one case where perhaps Justice Alito's vote was decisive last term. It's the case of Hudson versus Michigan. The reason that I say that perhaps Justice Alito's vote may have been decisive is it's a 5-4 case in which Justice Alito sided in this case with the state of Michigan. It was a case that was initially heard when Justice O'Connor was still on the court, and it's quite possible that she tentatively had sided against the state of Michigan with the criminal defendant in the case. So here's a situation where, at least according to, if you read certain tea leaves, it seems that the shift from Justice O'Connor to Justice Alito may have made a difference on the court. Here's the case. It's well established, and no one on the court disagreed, that in a variety of situations, the police, when they get a warrant, have to knock and wait a little bit and announce their presence, wait 10 to 15 seconds before they enter the dwelling place. If the door is open, great. If not, again, they knock and announce their presence, and then after a little bit of time, they can come in. Now, sometimes there are exceptions in cases of danger and risk of destruction of evidence, but in this case, no one was really arguing, or the Michigan was not arguing that the exception actually applied. So the case was argued under the premise that the police were supposed to knock and announce. They had a warrant. They were looking for drugs, and they had the warrant, but they didn't really wait the 10 seconds. They sort of knocked and then just came in, and they found cocaine. They found what they were looking for. And the question is whether the cocaine should have been suppressed, should have been excluded, because they didn't follow the rule of waiting the 10 to 15 seconds. And by a vote of 5-4, the Supreme Court said that exclusion is not required in this situation. Now, really small set of facts, but the reasons that were given are quite significant and may foreshadow something interesting in future cases. Here's one argument. And remember, Justice Alito is the swing voter, in effect, on this, because it's 4-4 when he joins the court. The opinion of the court, written by Justice Scalia, makes a couple of arguments. Here's one. There's no causation. There's no causal link between the violation, you didn't wait the 10 to 15 seconds, and the finding of the cocaine. If you had waited 10 to 15 seconds, you would have found the cocaine 10 to 15 seconds later. So what's the difference? And if they would have gotten rid of the cocaine in that 10 to 15 seconds, well, then maybe you shouldn't have had to wait it in the first place, by the way. So that's one argument. There's no causation. That's actually a really significant one when you think about it. I'm going to give you another line of cases where that could be very significant. Another thing that the majority said is there's no real good fit between exclusion of evidence and the relevant values that the Fourth Amendment is designed to serve. In fact, civil damage actions might be a better way in a variety of situations of vindicating the Fourth Amendment. So why would it ever matter whether you waited the 15 seconds? Here's a case, and Justice Scalia sort of hinted in this. I'm sort of, I think, elaborating a little bit his intuition. Let's imagine not a guilty homeowner where you find the drugs. Let's imagine an innocent homeowner. She's in her nightgown, and you don't wait the 15 seconds, and you just bust in, and she hasn't even had a chance to cover up. Now, you can see the harm that's done by that failure to wait 15 seconds, but let's imagine the cops don't find anything. She's innocent. The exclusionary rule does her no good at all. It really isn't connected to the real wrong. The wrong isn't really done to the guilty person when you find the cocaine 10 seconds later. It's really done to the innocent person when her privacy and dignity have been invaded without proper respect at the door. And the suggestion really by the court is there actually is a better way to remedy for certain sorts of Fourth Amendment violations. It might be, for example, in a civil damage action, a Bivens type of action if it's the FBI that blunders in, or a 1983 suit, a civil rights action, if it's state or local police. And punitive damages might issue. I wouldn't mind being on the legal team taking that case on a contingency fee basis because, to a local jury, maybe outraged by the violation of privacy and dignity. That's the kind of case where the Fourth Amendment would be properly vindicated, not this one where the guy's trying to exclude evidence where they would have found it anyway, 10 seconds later. Those are the two arguments basically made, and the dissenters said, basically, the Constitution was violated, the Fourth Amendment was violated, and what we do in Fourth Amendment violation cases is basically exclude evidence, and the dissent was written by Justice Breyer. But with these two lines of argument that the majority put forth, let me give you a couple of future cases where this might be very significant. The no-knock case, there's just a small set of facts. Here's a much bigger situation. The police don't get a warrant. See, in this one, they had a warrant, and actually the majority emphasizes, and Justice Kennedy, who writes a separate concurrence, emphasizes, here they had a warrant. You need to understand that. So they're not just blustering in without a warrant. And the dissenters say, yeah, but they didn't comply with the warrant, because the warrant said wait 15 seconds, and they didn't. So that was the debate. Imagine a situation where the cops don't have a warrant, but they do have probable cause. They could have gotten a warrant. Let's imagine that they didn't because they thought this case fell into one of the very many exceptions to the so-called warrant requirement. And the police, in good faith, didn't get the warrant, but they could have easily. It would have easily issued. They go, they find the stuff. And now they say, it's true that we violated the Fourth Amendment because we were supposed to get a warrant, but we could have got one anyway. It would have issued, and if it had, we would have found the stuff just the same way. Now, that's not a small category of cases. That's a lot of cases. In many, many cases, actually, the Supreme Court has excluded evidence where there was probable cause. A warrant clearly would have issued, but but it didn't on the facts of this case. Now, are they going to apply that idea, no causation? If so, this is actually now a pretty big exception to the exclusionary rule. Justice Kennedy could say, oh, no, that's a very different case, because in this new case, no warrant actually was issued, whereas in Hudson it did. On the other hand, in the case I'm positing, the cops also were acting in good faith, and here they didn't quite give a reason why they just blustered in. Let's imagine a second line. California or some other state reads this opinion and say, the Supreme Court is telling us the exclusionary rule is not great in a whole bunch of situations. Civil damages are a better way to go. They're actually the way the founders, no founder believed in the exclusion of evidence. No English court ever excluded evidence on Fourth Amendment grounds at the time of the founding. No American court, state or federal, ever did so for the first 100 years after the Declaration of Independence. So the exclusionary rule is a distinctly modern creation, and the court is saying a costly one, and one that really doesn't fit the right. The right is really about the right of innocent people, not quite the right of guilty folks to get away with it. So California reads all that. Some other state says, you know what we're going to do? We're going to provide more remedies for innocent people. We're going to get rid of sovereign immunity. We're going to waive qualified immunity of government officials. And if we really provide full remedies for the innocent, we'd like to opt out of the regime of exclusion. And you laugh, but I'm not at all sure that the Supreme Court says now that that's impermissible. They may actually be encouraging states to consider creating alternative remedial regimes to exclusion that may better fit the real violation, which, as I said, is most clearly seen with the innocent homeowner rather than the guilty drug dealer. That's Hudson. In another important criminal procedure case, set of cases last term, the Supreme Court clarified the confrontation clause. So if you take the Fourth Amendment seriously, it actually isn't so great for certain criminal defendants because it actually wasn't about the exclusion of evidence, and the Supreme Court hasn't gotten rid of the exclusionary rule, but it said some things that might cut back on the exclusionary rule or allow a cutback. Here's a different constitutional provision, and on this one, maybe taking it seriously helps criminal defendants rather than hurting them. The Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to be confronted with witnesses against him. For a long time, courts didn't, if you read that language, it's absolute. It says the accused shall enjoy the right, but courts didn't read it in an absolute way. They basically said, well, you know, you can't really always allow the defendant to confront the witnesses against him. And they did so basically by saying all sorts of times hearsay evidence is introduced and we allow it because we create exceptions to the hearsay rule, and if those exceptions are reasonable, then we're going to deem the confrontation right satisfied. And Justice Scalia and others say, well, where does it say that in the Sixth Amendment? Isn't this an absolute right? And if it is, how could it sensibly be an absolute right given that we have all sorts of exceptions to the hearsay rule? Reasonable exceptions. Answer, the hearsay rule is actually different than the confrontation clause. We need to have a better definition of who is a witness within the meaning of the confrontation clause. So if Bob sees Doug and starts chatting and says, you know, I saw Akil running across the street yesterday and he was acting kind of weird. And then later on, it becomes apparent that a crime was committed on that day. And Bob is now off trekking in Nepal, and so he's unreachable. But Doug takes the stand and says, well, Bob told me that he saw Akil running around that day. I'm on trial in this hypothetical. That's hearsay. And it might fall into an exception or not. We would have but is it a confrontation clause violation? I'm not getting to look Bob in the eye. On the other hand, is Bob really the witness? He never took the stand. He never talked to the police. He never swore an oath. At the time that he was talking to Doug, the crime may not even have fully occurred. Maybe actually I was running across the street as part of a plan where the last criminal act was several days later. He may not have even known that there's anything criminal about my conduct when he was talking to Doug. In what sense is he the witness? This is the new approach to this confrontation clause that the Supreme Court is moving to, a more textualist approach. Confrontation clause is absolute, but not everything is really witnessing. Certain out-of-court statements really aren't properly understood as witnessing. So, how do we think about it? Let's take case one. Here's the easy case. If it would be wrong for the court, for a state or a federal government to try me as a defendant, have Bob testify under oath to the jury, and just exclude me from the proceeding. That's obviously a violation of the Confrontation Clause. Now, wouldn't it be equally obvious if instead of that, the day before the trial, the government videotapes Bob under oath, he gives a full deposition, an affidavit, and then I'm not there. They exclude me, and they introduce that affidavit and deposition to the jury. That's sort of the same thing. Well, if you're with me so far, how about if the deposition or the affidavit that the police get isn't the day before the trial, but a month before the trial, and it takes place in the police station? Maybe the same result. The police are, in effect, getting his testimony, getting his affidavit, and not letting me look in the eye. They're treating him really as the witness, and he's acting as a witness under oath and with full transcription. Well, what if it's not under oath at the police station? Is that witnessing? Now we're starting to get a little closer to the line. But what is clear is when Bob talked to Doug and the police weren't remotely involved, and Bob may not even known that there was a crime going on, and the crime may not have even occurred at that point, that is not witnessing. That raises hearsay questions, but not confrontation clause issues. So the court is now basically trying to draw some fine lines. Justices Thomas and Scalia, who both actually led this revolution away from a hearsay approach toward a more categorical approach, are now beginning to disagree amongst themselves in these close cases. Let me just give you the facts of the cases before the court last term. They're 911 cases in one situation. Woman calls up, tells the cops that something bad is happening to her, can they please come? And then let's say that 911 recording is introduced at trial. Is that like an affidavit or not? Court says, no, that really wasn't, that was trying to help out someone in an emergency. That wasn't a criminal interrogation. It wasn't like an affidavit or a deposition quite. But it might be different if after the emergency is passed, the police go to her house and start questioning her about what happened and then introduce that transcript. That looks more like an affidavit. Okay, so they said one other thing in these cases that's interesting. Suppose the unavailability of the victim, she doesn't want to testify at trial, is because actually the defendant really beat her up and threatened her and she's really afraid for her life. Has the defendant, by his own misconduct, forfeited his right to the confrontation? Should he be stopped from complaining if the reason she's not testifying is that he's really threatened her? And it's tricky because, of course, whether he threatened her or not is very closely connected with whether he's guilty of the underlying offense for which he's been charged, but the court has opened up the possibility that they're going to take forfeiture and estoppel very seriously in future cases. How many minutes left do we have, Doug?
About 5.
Okay. Two more issues, and then I'm going to sit down. One is the issue of peremptory challenges. In a case that came out of California, a case called Rice versus Collins, the issue was whether the prosecutor had used race impermissibly in challenging a would-be juror. And the state courts, because it's unconstitutional, everyone agrees to exclude someone from being a juror because of her race, whether the person trying to do the excluding is the prosecutor or the defense attorney for that matter. You're not supposed to use race in picking jurors, but see the O.J. Simpson case. And I'm going to come back to that since we are here in Los Angeles. Everyone agrees you're not supposed to use race. The question, though, is, did you? And there are real questions of credibility and proof. In In the case of Rice versus Collins, the state courts, looking carefully at the issue, said, we're convinced that the prosecutor really wasn't excluding juror number 16 for racial reasons. He was instead excluding her because she rolled her eyes and she seemed young and not and maybe soft on crime, not because of her race as such. And the Ninth Circuit said, we don't buy it. We think it was race. And the Supreme Court overruled the Ninth Circuit. They do that a lot. And they said, no, you're supposed to take seriously reasonable determinations of fact made by state courts, and this was a reasonable call. And that was unanimous. Here's the news. So none of that is news, that the Ninth Circuit is sometimes off the reservation more than sometimes, that the Supreme Court unanimously strikes it down. There's one judge, for example, on the Ninth Circuit who was unanimously struck down a few terms ago 5 times by the United States Supreme Court. This judge is a graduate of the Yale Law School. So that's not news, that the Ninth Circuit is actually being reversed unanimously a lot by this court and by previous courts, more than any other circuit, by a very wide margin. And maybe if we want a different kind of panel, we could talk about that, because I think that actually is an important issue for lawyers to think about. But what the news is Justice Breyer, joined now by Justice Souter, said we should get rid of peremptory challenges altogether. We should be abolitionists about this. Because as long as we allow peremptory challenges, they're going to be used for race-based and other ways in ways that are difficult to prove, or gender-based ways in ways that are going to be difficult to prove. And here, by the way, what was the permissible justification? She was young. She was over 18, old enough to vote. Think how outrageous it would be if we let registrars say, well, you're over 18, but you look too young, so we're not going to let you vote. And if you're old enough to vote, why aren't you old enough free from discrimination? There's a constitutional amendment that you can't discriminate against someone in the vote because they're 19 as opposed to 29. Why should we be discriminating against people in jury service because they're 19 instead of 29? Why shouldn't basically all Americans who have a right to vote have a right to serve without discrimination in the courtroom itself? This is what Thurgood Marshall said a generation ago. Steve Breyer, last term, or 2 terms ago, first took up this cause. Now Justice Souter has joined him, so you might hear more about this. Wherever 2 or more gather in the name of a certain idea, sometimes things follow. So keep an eye on that for the future. Okay, finally, what Justice Alito was being asked about: actual innocence, DNA, the death penalty. The Supreme Court decided more than a couple of cases this term, and I really do wonder whether we've got the big picture right here. In one case, the case of Kansas versus Marsh, the question was whether when the aggravating factors are balanced perfectly against the mitigating factors, whether in the case of tie in that way you can ever have the death penalty. And the Supreme Court said, yes, you can. And dissenters said, you know, there's a lot of recent evidence that innocent people may be being executed, and that means that we should be very careful about the death penalty, and maybe in any close case side with the defendant. And Justice Scalia, responding to the dissenters, says, this case at hand has nothing to do with innocence. He says, the dissenters' proclamation of their policy agenda in the present case is especially striking because it's nailed to the door of the wrong church. That is, set forth in a case litigating a rule that has nothing to do with the evaluation of innocence or guilt. Okay, because he says this is just about aggravating and mitigating factors. There's no debate about whether the person did it or not. Maybe he's got a point. But now take cases where there is a real debate about whether the person did it or not. In fact, let's imagine a case where it's pretty clear that no reasonable juror could decide beyond reasonable doubt that he did it. Can we still execute him? That was the question that Justice Alito gave a very long-winded non-answer to, at least before we cut him off. You know, we're talking about procedure. Well, what about innocence. If you don't like the exclusionary rule, you think because it should be about guilt or innocence, not about these crummy technicalities. Well, what about when the person actually is innocent? In a case called House versus Bell, there was DNA evidence. It was a death case. And the court basically, here's what it said. And some justices said, actually, the DNA evidence doesn't prove that he's innocent. The court thought, at the very least, proved that there was clearly reasonable doubt. Here's what they said, per Justice Kennedy. While this is not a case of conclusive exoneration, and the issue is close, this is the rare case where, had the jury heard all the conflicting testimony, including some DNA evidence that they didn't get a chance to hear, that pointed away from the defendant, arguably, it is more likely than not, it's probable, that no reasonable juror viewing the record as a whole would lack reasonable doubt. So if they had had this evidence at the trial, none of the jurors should have voted to convict. A judge should have ordered an acquittal as a matter of law. What happens to the defendant in this case? Does he get acquitted as a matter of law? No. Does the court even say, well, at the very least, you can't put him to death? No. All that follows when no reasonable juror could have found, more likely than not, that this person did it beyond reasonable doubt, is that he gets to argue his procedural technicalities. That's what Justice Alito, then Judge Alito, was beginning to tell you in that proceeding, and I wonder whether we're missing the basic point, which is about, it should be, I think, about innocence. It should be about guilt or innocence in the exclusionary rule context, and that may not help the guilty defendants, but it should be about guilt or innocence in the case of newly discovered evidence, especially, I would think, in death cases. And it isn't quite in either. And then across the board, I've argued, it should be also about non-discrimination, and we should, in fact, get rid of the peremptory challenge. We should take up the challenge that Thurgood Marshall offered up a generation ago and that Justices Breyer and Souter are beginning to pick up today. Thank you very much.
We have a question from David Savage.
Well, Akil, how about giving an answer to the sort of intriguing proposition you threw out? Why not, should the court overturn the exclusionary rule, and what would take its place? I can imagine, as you said, that there's a lot of good arguments against the exclusionary rule, but what if I'm a member of the LAPD, the court overturns the exclusionary rule, and I say, from now on, these drug cases, let's go out there, let's break in the house, break down the door. Most of the time, they're going to be drug dealers, and we're home free. Maybe 1 out of 20 or not, and let them sue it, it'll take a long time. But the police take that from, if there's no penalty for violating the Fourth Amendment, they could just routinely violate the Fourth Amendment and occasionally maybe have to deal with a lawsuit down the road.
So let me flip it around and talk about all the cases where right now, unless you have a robust regime of civil damages, there's no remedy. If the cops know I'm innocent and they just want to harass me because of my race or my politics or my gender, if they strip search me and humiliate me, and they know I'm innocent, so there's nothing to exclude. They rough me up, police brutality cases. For many people in the shoes of Webster Bivens, an innocent man degraded by police officers, this is a famous line from the case of Bivens, damages or nothing. The way we vindicate constitutional rights across the board is using techniques of damages, punitive, how we vindicate due process cases and equal protection cases and just all sorts of other constitutional. So you could never rely solely on exclusion just because it would be open season on the innocent people of the world. Now, I actually think we're not doing right by the innocent people of the world. We've created too many governmental immunities, even in cases of clear constitutional violations. But once we actually start to remedy that situation, and cases like Hudson are perhaps encouraging legislatures, state legislatures, and even state judges to think about remedial alternatives, then the question is, if we really do have robust forms of deterrence and punitive damages in these other areas, do you need to rely as heavily on exclusion as you had in the past? So what gets the LAPD's attention? Well, when They brutalize Rodney King, and a civil damage action is brought, and millions of dollars of punitive damages are assessed, and taxpayers begin to say, well, should we pay for this? You know, should our police department be doing this? Because when you start adding zeros to the end of these awards, it starts to eventually get people's attention. You know, and so I think the problem right now is that the old style thinking is exclusionary rule actually really is a pretty good remedy, when in fact it is. And I'll say it one other way. James Madison was no dope. Neither was James Wilson or Alexander Hamilton or any of these guys at the founding. Not one of them ever believed in the exclusion of evidence. They did very much believe in the Fourth Amendment. They drafted it. They did very much believe in some of these remedies that courts in the 20th century actually cut back, even as they were creating more remedies for, more opportunities for guilty defendants. So I actually think, just on kind of, if the Constitution was just neutral on this, that we should at least think about how we might be able to improve these other remedial mechanisms.
I'm not sure I know the answer. If you were on the court, would you...
God forbid.
Would you vote to overturn the exclusionary rule and assume states are going to come up with remedies? Or would you just talk about it that maybe someday, you know, this is really not a good remedy, someday we ought to do something? I mean, should the court overturn the exclusionary rule and allow states, or say to states, hey, you ought to come up with some better remedies?
So let's redirect the question away from what I would do, but what a proper court should do. A Roberts court, a court that believes in a certain kind of judicial restraint. And I want to make 2 points. One, judicial restraint can cut in different ways. If you're restrained vis-a-vis the Constitution, you just say the Constitution actually doesn't require exclusion. It really doesn't. This was a made-up judicial rule, and so we should abandon it because we're imposing a rule on states and the federal government that just ain't in the Constitution. That's one vision of judicial restraint. But that's what someone who believed in text, history, and structure might say. But someone else, like Chief Justice Roberts, says, well, you know, precedent is important too, and tradition, and gradualism, and I don't want to preside over radical changes in a standard operating procedure. So now, and they're distinguished proponents of both versions of judicial restraint. People who say, it's the Constitution that we have to follow, and that's it, and people who say, precedent is important too, gradualism is important too. This case, it seems to me, blends, in my view, and I know my old boss, Steve Breyer, would totally disagree with me. He dissented in the case. But both versions of judicial restraint. Justice Scalia hints in the opinion at the lack of strong constitutional foundations for the exclusionary rule, but all he does is simply begin a process by which actually perhaps exclusion will be whittled down in some cases and other remedial schemes will start to build up. So not a lot was actually done in Hudson, very, very subtle, and it's possible over the next decade, perhaps we'll see a little bit less exclusion, a little bit more other remedial mechanisms. That would be a good trade-off if it could be done. In my view, I'm sure Irwin thinks that would not be a good trade-off.
Professor McGoldrick, I think you have some questions from the audience.
One student asks, is it not true that the Hudson case will lead to more violations of the knock and announce rule, more imperialistic tactics?
Instead of trying to figure out, so you're the cop, and you're gonna bust in or not. I'd want you, in fact, to try to think about what's the likelihood I'm going to be busting in on an innocent woman in her nightgown. Because if the likelihood is significant to that, I really should knock and announce, because that's actually where the Fourth Amendment harm would be done. If the likelihood is zero of that, well, then if I do this thing, again, I'm not sure what the harm was. You found the cocaine 10 seconds later. Let's be clear about what we're talking about here. That's all that happens when you don't wait the 10 seconds in the case of guilty defendants who don't have any sort of privacy concern. I'd want you to actually be thinking about, well, suppose even he's guilty, but he's in his underwear. Guilty people are in their underwear, too. And guilty people have constitutional rights. The same as anyone else, but no more. Exclusion, in fact, gives them some special get-out-of-jail-free card. I'd want anyone, guilty or innocent, to be able to basically say, you intruded on my privacy. There was a harm when you failed to wait the 10 seconds, and here's what the harm was. In Hudson, I didn't quite see what the harm was because they just found the cocaine 10 seconds earlier. But in a case where people are busted in upon in ways that do violate their privacy and dignity, there might be serious harm, and I'd want the cops to really think about, anticipate that, and be ever more careful if there's any possibility of that. And damage actions do, especially if you have sufficient punitive damages, do begin to get their attention of police departments if their budgets are being devoted to paying off damage awards rather than paying for good police work.
We're going to turn to civil rights, and as we do welcome back, as the dean said, a great friend of the law school who's visited with us many times for the Judicial Clerkship Institute, who's a superb teacher, and who will give us an overview of the civil rights cases from the past term, but those will be introduced by the Chief Justice as well. Let's hear a word from John Roberts.
Do you have any concerns or reservations about the constitutionality of the 1964 Civil Rights Act that outlawed racial discrimination in public accommodations, employment, and other areas?
I don't think any issue has been raised concerning those. I'm cautious, of course, about expressing an opinion on a matter that might come before the court. I don't think that's one that's likely to come before the court. So I'm not aware of any questions that have been raised concerning that, Senator.
So I'll assume that you don't feel that there are any doubts on the constitutionality of the 64 Act. Do you have any doubts as to the constitutionality of the 65 Voting Rights Act?
Well, now, that's an issue, of course, as you know, is up for renewal, and that is a question that could come before the court. The question of Congress's power, again, without expressing any views on it, I do know that it's going to be...
Well, that's gone up and down the Supreme Court, the 65 Act, and again the 1982 Act extension.
Yes, and the issue would
I'm just trying to find out on the Voting Rights Act whether you have any problem at all and trouble at all in terms of the constitutionality of the existing Voting Rights Act that was extended by the Congress.
Well, the existing Voting Rights Act, the constitutionality has been upheld, and I don't have any issue with that. There's a separate question that would be raised if the Voting Rights Act were extended, as I know Congress is considering. And those arguments have been raised about whether or not particular provisions should be extended or should not be extended. And since those questions might well come before the court, I do need to exercise caution on that.
But with regards to the act that we passed, a bipartisan act, I'm going to come back to it, and about your position on the 1982 Act. I know you had concerns, and I'm going to come back to those. But you're not suggesting that there's any constitutional issue with that.
I'm not aware of any constitutional issue that's been raised about it. But again, I don't want to express conclusions on hypothetical questions, whether as applied in a particular case, whether there be a challenge in that respect. Those cases come up all the time, and I do need to avoid expressing an opinion on those issues.
Erwin Chemerinsky.
Thank you. Thank you. Thank you so much. It's really an honor and a pleasure to be here as part of this wonderful symposium and as part of this distinguished group of scholars and journalists. I believe we've now entered the era of the Anthony Kennedy Court. I know out of tradition and deference to the chief, we call it the Roberts Court. And I have no doubt there'll be a point in time where it's appropriate to speak of a Roberts Court. We have to remember, though, that John Roberts was 50 years old when he was sworn in last fall. He remains on the court until he's 86 years old. The current age of Justice John Paul Stevens, he'll be on the court until the year 2041. So what we think of the Roberts Court is much more likely to be based on who are the justices in the 2020s and the 2030s than who was on the court in October term 2005. I think on the current court there are 4 very conservative justices: Chief Justice Roberts and Justice Scalia, Thomas, and Alito. There was only one instance last year in a non-unanimous case where Chief Justice Roberts didn't vote and would identify as the conservative direction. There was not a single instance last year when Justice Alito didn't vote and would identify as the conservative direction. There are no liberals on the current court in the mold of a William Douglas, a William Brennan, Thurgood Marshall, but there are 4 moderate liberal justices who more often than not vote together in 5-4 cases, and those would be Justices Stevens, Souter, Ginsburg, and Breyer. That so often leaves Anthony Kennedy in the middle. Last year, there were 12 5-4 decisions. Anthony Kennedy was in the majority in 9, more than any other justice. If you include 5-3 decisions, and there were a number last year, Justice Kennedy's influence becomes even greater. Justice Kennedy is quite self-conscious about this role. In a number of the most important cases of the term, where Justice Kennedy was in the majority in a 5-4, he wrote a separate opinion that determined the scope of the holding. Speaking as a lawyer who often writes briefs to the court and occasionally argues them, I realize that now it's often a matter of arguing an audience of one. I'm currently in the process of writing an amicus brief in 2 cases before the Supreme Court, whether schools can use race in assigning students as part of achieving desegregation. In the privacy of this room and the C-SPAN audience, I see little chance that our side will get Roberts or Scalia or Thomas or Alito. I feel it's fairly likely that our side, supporting the ability to achieve desegregation, will get Justices Stevens, Souter, Ginsburg, and Breyer. So I regard my brief as a shameless attempt to pander to Justice Kennedy. If I could put his picture on the front of my brief, I would do so. And I don't think this case is atypical. I've been asked to talk about civil rights, and Doug assigned me to talk about 3 free speech cases, 1 religion case, 1 abortion case, and 1 criminal procedure case. He said, do it in 20 minutes and find common themes that unite these cases. The only common thing I could find about these cases, petitioners won some and respondents won others. Let me start with speech, because there is a common theme of the 3 speech cases I was asked to talk about. Free speech lost last year in the Supreme Court. In all 3 of these free speech cases, the Supreme Court ruled in favor of the government and against the free speech claim. The case of these that I regard as the most important is Garcetti versus Ceballos. Ceballos worked here in Los Angeles County as a deputy district attorney. He became convinced that a witness in one of his criminal prosecutions, a deputy sheriff, wasn't telling the truth. He investigated and he wrote a memo to that effect. His supervisor said, tone down the memo, don't be so critical of the deputy sheriff. The deputy district attorney turned over his beliefs to the defense lawyer, believing he was required to do so under Brady versus Maryland. The deputy district attorney, according to his complaint, then suffered reprisals. He was removed from his supervisory position. He was transferred to a less desirable location. He brought a lawsuit saying that such reprisals violated his free speech rights. The Supreme Court heard oral arguments in October and then put over the case for re-argument after Justice Alito replaced Justice O'Connor. They put over 3 cases last term. All came out 5-4, all with the same justice in the majority. In this case, Justice Kennedy wrote the opinion for the court, joined by Chief Justice Roberts, Justice Scalia, Justice Thomas, and Justice Alito. Justice Kennedy held that speech by government employees in the performance of their duties is not protected by the First Amendment. Justice Kennedy said there's a distinction when someone speaks as a citizen as compared to speaking as a government employee. Justice Kennedy said the First Amendment only safeguards the former. As the dissenting justices pointed out, there'd be 3 answers to this question. You could say always speech by government employees in the performance of their duties is protected. You could say sometimes it should be protected. Or you could say never it's protected. Justice Kennedy's answer is that's never protected. Now, I could criticize the case based on what seems to me a false distinction between talking as a citizen and talking as a government employee. Surely government employees don't give up their citizenship when they walk into the government office building. But to me, the real consequence of the case, and why it's so misguided, is that it would be much less likely that wrongdoing will be exposed by government employees. About 6 years ago, when I was still living in Los Angeles, I was asked to do a report on the Los Angeles Police Department after the Rampart scandal. As part of that, I interviewed between 75 and 100 police officers. During these interviews, I repeatedly heard and learned a new phrase, freeway therapy. I was told by officers that if they filed complaints about wrongdoing by other officers, they would find themselves transferred to the precinct farthest from where they lived. So the officer down in the harbor area would find that he was transferred to the northernmost reaches of the valley, a 2-hour commute. When the Christopher Commission wrote its report on the Los Angeles Police Department following the Rodney King beating in 1991, it said that the code of silence is the single greatest obstacle to dealing with problems of police abuse and police brutality. Well, the result of Justice Kennedy's opinion is that an officer who suffers reprisals for reporting wrongdoing by other officers has no First Amendment protection at all. I think this case is not only a loss of free speech rights for millions of government employees, but it's a really loss for the general public, much less likely to have government employees exposing wrongdoing on the job. The second speech case I was asked to talk about is called Rumsfeld versus the Forum for Academic and Institutional Rights. The American Association of Law Schools has long had a policy whereby its member schools do not allow employers to use law school career service offices if the employers discriminate on the basis of race, gender, religion, or sexual orientation. As a result of this policy, most law schools in the United States would not allow the United States military to use law school career service facilities. The reason for this is there's a federal statute that says that gays and lesbians are not allowed to serve in the military. Law schools are treating the military like any other discriminatory employer. Now, in reality, the military could still recruit on campus. They could go to the ROTC building, they go to a hotel across the street from the law school, but they couldn't use career service facilities. A representative from New York by the name of Gerald Solomon introduced a bill that said if any part of a university discriminates against the military, then essentially all of the university would lose the entirety of its federal funds. Now, law schools don't get that much in the way of federal money, but universities, especially those with medical schools, science departments, engineering schools, are very dependent on federal money. As a result, a group called the Forum for Academic and Institutional Rights was formed to challenge the Solomon Amendment. I should disclose here that I'm not only a member of the board of directors of the Forum for Academic and Institutional Rights, but I'm a named plaintiff in the lawsuit of Fair versus Rumsfeld. In many roles in the 30 years since I graduated law school, it's my first time as a plaintiff in a lawsuit. If you actually read the complaint, it says, Fair, Erwin Chemerinsky, a law professor in California, Sylvia Law, a law professor in New York, and 2 law students. I joined this suit as a plaintiff. You remember the board of directors of the Forum for Academic and Institutional Rights, because I think it's so important that all of our law school facilities be available to all of our students, and that any employer that discriminates should not be allowed to use law school career service facilities, whether that's the United States military or private law firm. Well, we won in the United States Court of Appeals for the Third Circuit. The Third Circuit found that the Solomon Amendment was compelled speech by law schools. It forced law schools to convey messages from the military in the form of posting announcements, sending emails, allowing banners to be posted. Additionally, the Third Circuit said this violated freedom of association for law schools. That law schools had an expressive message that was anti-discriminatory, and to force them to include employers that discriminated violated this. The Supreme Court, in an 8-0 decision, reversed the Third Circuit. I went home and told my son that we lost 8-0. He said, "How did you lose 8-0? So only 8 of the justices were participating." Chief Justice Roberts wrote the opinion for the court here. He said, first, with regard to compelled speech, this doesn't keep law schools from expressing any message they might want to convey. Law schools can still organize rallies, say anything they want to protest the military's exclusion of gays and lesbians. And he said as to compelled association, that those cases really have been about membership. This doesn't involve membership at all. Now, if the Supreme Court were to follow Fair versus Rumsfeld in the future, I think this is a significant change of First Amendment doctrine. Never before has the Supreme Court said that compelled speech is allowed so long as the compelled speaker can disagree with the message. Think back to the most famous compelled speech case, West Virginia Board of Education versus Barnett, where the Supreme Court said forcing children to salute the flag violates the First Amendment. The court didn't say it's okay so long as the kids can then object to the flag they saluted. Or think back to Woolley versus Maynard. This involved New Hampshire requiring license plates to say live free or die. The court didn't say, well, New Hampshire can require live free or die on license plates so long as drivers can have bumper stickers next to it saying they don't want that on their license plates. This is the first time the Supreme Court ever said compelled speech was allowed just because the speaker could then disagree with another message. But I don't think this case is likely to have much effect into the future. I think this is really a case about judicial deference to the military and congressional judgments about the military. In fact, at the very beginning of his majority opinion, Chief Justice Roberts put this case in that context. There's a long judicial tradition, I think largely a tragic judicial tradition, of judicial deference to the military in wartime. I think here of cases like Korematsu versus the United States that upheld Japanese internment during World War II. I think this is where that case fits. One other free speech case I'd mention, a case called Beard versus Banks. Pennsylvania had a regulation for its top security prisons that prisoners would not be allowed to have access to any newspaper, any magazine, or any photograph, including family photographs. The United States Supreme Court, a 6-3 decision, upheld this as constitutional. Justice Breyer wrote the opinion for the court. Here only Justices Stevens, Souter, and Ginsburg dissented. Justice Breyer said that prisons can restrict prisoners' free speech rights so long as the prison's action is rationally related to a legitimate penological objective. Justice Breyer said the state argues that prisoners in these facilities will have an incentive for better behavior to get back the privilege of reading newspapers, magazines, and having photographs. And so, in order to give prisoners this incentive, the court would defer to the prison authority. Justice Souter in dissent objected and said, to keep a prisoner from even having family photographs was a form of mind control unacceptable under the First Amendment. I'd also note that Justices Scalia and Thomas wrote a separate opinion in which they thought that Justice Breyer's approach, which seemed almost completely deferential to prison authority, was not deferential enough. Justice Scalia and Thomas said they would go towards total deference to prison authorities in this context. There's one religion case that I've been asked to talk about. It's a case that's called Gonzalez versus Centro Esperada. And it involves a very small religion that comes to the United States from the Brazilian rainforest. It has as a sacrament brewing a tea, and as part of that hallucinogenic substance release called DMT, it's banned under the Controlled Substance Act. According to the record, there are about 180 adherents to this religion in the United States. They brought a lawsuit against the Attorney General seeking a declaratory judgment they had the right to use this substance and brew their tea pursuant to the Federal Religious Freedom Restoration Act. In 1990, in a case called Employment Division versus Smith, the Supreme Court very much narrowed the protections of the Free Exercise Clause. In 1993, Congress passed, and President Clinton signed, the Religious Freedom Restoration Act to try to restore religious freedom by statute to what it had previously been under the Constitution. The statute says whenever the government significantly burdens religion, it has to show that its action is necessary to achieve a compelling government purpose. What's referred to as strict scrutiny. In 1997, in City of Bernie versus Flores, the Supreme Court declared unconstitutional the Religious Freedom Restoration Act as applied to state and local governments. The Supreme Court said it exceeded the scope of Congress's power to regulate state and local governments under Section 5 of the 14th Amendment. But the issue remained open. Is the Religious Freedom Restoration Act still constitutional as applied to the federal government? I think the court implicitly answered that question in Ocentra. In the unanimous case, the Supreme Court ruled against the federal government and in favor of the small religion. Chief Justice Roberts wrote the opinion for the court. Chief Justice Roberts says that the government has the burden of proof under the Religious Freedom Restoration Act, both at a preliminary injunction stage and at trial. He said that the government failed here to show that prohibiting this religion from making this tea was really necessary to enforce the Controlled Substance Act. It's so unlikely that allowing the small group to make this tea would really undermine federal law enforcement efforts. I think this case is important because it indicates that the court does treat the Religious Freedom Restoration Act as constitutional, as applied to the federal government. I also think it shows that the court is using a very robust, traditional form of strict scrutiny under the law. The abortion case that I was asked to talk about is Ayat versus Planned Parenthood. It is the first time in American history the Supreme Court's ever been unanimous in an abortion case, and that should tell you the Supreme Court decided nothing. What was involved here is New Hampshire adopted a law that required parental notification before an unemancipated minor could receive an abortion. In order for a doctor to perform an abortion without parental notification, in accord with Supreme Court precedent, the law says that a judge could approve the abortion either by finding the minor's best interests or by concluding that she's mature enough to decide for herself. The United States Court of Appeals for the First Circuit declared the law unconstitutional. The First Circuit said any law like this has to have a health exception. It has to allow a doctor to perform an abortion without either parental notification or judicial approval if the health of the minor warrants it. Imagine a girl comes to a doctor's office and she's hemorrhaging. Her life's not in danger. There's a separate exception in law for that. But the doctor believes her health would be in danger by waiting for either parental notification or judicial bypass. The Supreme Court, First Circuit said, without such a health exception, the law is unconstitutional. The United States Supreme Court did not decide this issue. Instead, the court, in an opinion by Justice Sandra O'Connor, sent the case back to the First Circuit. The court asked the First Circuit if it be possible to craft an injunction or declaratory judgment as to the unconstitutional parts of the law while allowing the rest to remain. Now, Doug, in his introduction, talked about how the great unanimity that's shown in the statistics of this term reveals Chief Justice Roberts' influence. I think it reflects something else much simpler that's evident in this case. Sandra Day O'Connor participated in the oral argument calendars in October, November, December, and January. But she and her colleagues knew that she'd only be allowed to participate in the decisions if she was on the court the day that the cases came down. So I think there were an extraordinarily large number of unanimous cases early on where the court was deciding on very narrow grounds like Ayat. There were 2 abortion cases before the Supreme Court next term, and these are Gonzalez versus Carhart and Gonzalez versus Planned Parenthood. They involve the constitutionality of the Federal Partial Birth Abortion Act. I predict to you these will not be unanimous. In fact, even though I learned long ago that he who lives by the crystal ball has to learn to eat ground glass, I will give you a prediction here. I predict to you that both of these cases will be 5-4 decisions with Justice Kennedy in the majority. One more case I was asked to talk about, and this was a criminal procedure case. And this is United States versus Gonzalez-Lopez. And what's most interesting about this case was the split among the justices. It was a 5-4 decision with Justice Scalia writing, joined by Justices Stevens, Souter, Ginsburg, and Breyer. I don't think I can identify any other case where that was the split among the justices. What was involved here was a man was being tried in federal court in Missouri on a drug crime. He had a retained lawyer, but he wanted a lawyer from California to represent him. The California lawyer came to Missouri and applied for pro hoc vice status, permission to appear in that particular case. The judge denied the lawyer pro hoc vice status, saying that the lawyer had violated an ethical rule. The case went to trial. The defendant had another lawyer. The defendant was convicted. On appeal, the defendant argued that the lawyer of his choice had been wrongly denied pro hoc vice status and that this violated his Sixth Amendment right to have the counsel of his choice. The United States Supreme Court, in a 5-4 decision, agreed with the criminal defendant. Justice Scalia said that the Sixth Amendment right to counsel includes a right to the counsel of one's choice. Justice Scalia said it's undisputed that the district court made a mistake in denying the lawyer pro hoc vice status. Justice Scalia said this is structural error. The conviction has to be overturned without any need for the defendant to show that he was prejudiced. Justice Alito dissented and said the defendant should have to prove prejudice in this instance, which isn't shown. Now, the holding's more limited than it might seem. Justice Scalia said he was only talking about defendants with retained counsel, those they could afford. The case doesn't apply to defendants who have public defenders or appointed counsel. Also, Justice Scalia said this doesn't limit the ability of courts to set their own rules for pro hac vici. This only applies when a court wrongly denies a lawyer pro hac vici status. And maybe what this case shows the theme is, no matter how hard you study the Supreme Court, you can't always predict what they're likely to do. Thank you.
We have a question from Jenna Holland of the Associated Press.
Irvin, you started with Justice Kennedy, and he is the man we're all watching. I'm wondering, did he give any clues this term as to how he'll fulfill this center role and what we might see in the next term, which might have even bigger cases?
I think that is the key question. To me, what was most significant was how often he chose to write separately when he was in the majority in a 5-4 to determine the scope of the majority's holding. Let me just quickly mention a few examples. Hudson versus Michigan that Akil talks about. I see the significance of Hudson perhaps a bit differently than Akil. I think Justice Scalia showed that there were 4 votes in that case to overrule the exclusionary rule. Because I think all of the arguments Justice Scalia makes are arguments for eliminating the exclusionary rule, not just creating an exception for not going to announce. Now, I might want to pause here and say, to the extent that Chief Justice Roberts and Justice Alito were joining this, it seems to me to belie all of the discussion about precedent and super-duper precedent and all of that if they're willing to overrule Mapp versus Ohio from 1961 or Weeks versus United States from 1917. Justice Kennedy writes separately a concurring opinion in which he says, quote, "The continued operation of the exclusionary rule is not in doubt." He's showing that he knows that the continued existence of the exclusionary rule depends on him. Another case, Rapanos versus United States, which involves whether the Federal Water Pollution Control Act can be applied to interstate wetlands. Justice Scalia writes for the 4 most conservative justices, joined by Chief Justice Roberts, Justice Thomas, Justice Alito. Justice Kennedy concurs in the judgment and articulates what the holding of the case in terms of the Water Pollution Control Act. Hamdan versus United States that we're going to talk about. Well, there Justice Kennedy again writes a separate opinion that talks about what parts of Justice Stevens' majority opinion will be the majority and what aren't. So to me, in answering your question, I think it shows he knows that he is often the swing vote. Now, what that's going to mean for the 2 abortion cases or the 2 school segregation cases, I think the only thing we know is he's likely to be the swing vote, and the holding's going to depend on what he does.
Can I ask a follow-up to that, please?
Please.
I'm wondering, too, if as the swing vote, he's going to be similar to O'Connor in terms of crafting new standards. I mean, right now he's been writing in a way that sort of limits the scope of what a majority may be doing. But does he seem, in your opinion, yet to have that coming down the road as well?
I think it's a terrific question. I think so. And the Rapanos case that I briefly mentioned would be the example of that. Whereas Justice Scalia's plurality opinion would be very narrow about when does the Federal Water Pollution Control Act apply. Justice Kennedy, concurring in the judgment, says he's going to articulate the test. There's to be a significant nexus to navigable waters. Well, because that was the narrowest ground upon which a majority agreed, that test then becomes the holding. Now, I think where we see the difference from the Roberts to the Rehnquist court are those areas where Justice Kennedy is likely to be significantly more conservative than Justice O'Connor. And I think the 3 that I'd point to are separation of church and state, abortion, and affirmative action. And 2 of the 3 are at least implicated in cases for next term.
On this issue of writing separately, I can see I've persuaded lots of people that Kennedy has been eclipsed by Roberts and Alito's jurisdictional efforts. And I know it's common to say that the narrowest ruling in Rapanos is Justice Kennedy's, as you just did. But it seems to me that at least in some respects, Justice Kennedy's ruling is entirely different than the plurality's ruling, and therefore the Marx doctrine is very difficult to apply and gives very little guidance to people who are trying to comply with the statute.
It's not the first time I said this, but I respectfully disagree with you here.
Why did I anticipate that?
Just to put what Doug said in context, to start where we'd agree, in a case called United States versus Marks, the Supreme Court said if there's no majority opinion, then lower courts, lawyers are to treat as the holding the narrowest ground to which a majority agrees. In Rapanos, the 4 dissenting justices would have accepted the authority of the Army Corps of Engineers to regulate purely intrastate wetlands that connected tributaries to interstate waters. Justice Kennedy wouldn't go that far. He said he'll allow the Army Corps of Engineers to regulate intrastate waters so long as there is significant nexus to navigable waters. Justice Scalia, writing for Floor in the plurality, took a very different approach. He said, in order to be navigable waters, there has to be a permanent standing body of water, rivers, lakes, oceans, streams, and that's it. I think Justice Kennedy's opinion does then, under Marx, become the holding that has to be treated. Now, I agree with you. What's a significant nexus to navigable waters is going to be very difficult for lower courts to apply. But if I was, in a purely descriptive sense, having to advise lower court judges what's the test, I think that's the test that they have to use.
Yeah, although, again, there's disagreement over what is an interstate navigable water. It's obviously a very different definition for the plurality than it is for Justice Kennedy, and I see no overlap on that score. Other questions from the audience?
Irwin, in Stenberg v. Carhart, as you know, the court held that states could not prohibit partial birth abortion. Professor Amar, as you probably know, argued that the majority unwisely took the most extreme pro-choice position and then told everyone who disagreed that they must obey. Well, Congress and the majority of Americans refused to obey and passed the Partial Birth Abortion Ban Act. 2 questions about that. I agree with you that it's going to be a 5-4 opinion, but we'd like you to get a little more specific. One preliminary question is, where does Congress get the power to ban partial birth abortion? What's the federal interest? The second and more important question is, do you think the Supreme Court should uphold the law, especially because Congress found as a fact that partial birth abortions were never medically necessary?
Sure. Just so, again, everyone's on the same page, let me just say a word about Stenberg versus Carhart. It involved a Nebraska law that prohibited the procedure that's often referred to as partial birth abortion, though I should say that even that phrase is contested. It's a phrase that was coined by opponents of abortion rights. Those who believe in abortion rights would very much resist the phrase partial birth abortion. The Nebraska law prohibited the removal of a living fetus or a substantial part of a living fetus with the intent of ending the fetus's life. The Supreme Court, in a 5-4 decision in June of 2000, struck the law down. Justice Breyer wrote the opinion for the court, joined by Justice Stevens, Justice Souter, Justice Ginsburg, and Justice O'Connor. Justice Breyer pointed out that there was no exception in the law to allow doctors to use the procedure if it was best for the health interests of the woman. Also, the federal district court had found, as a matter of fact, that at certain points of pregnancy, especially in the weeks right before and after viability, this was often the safest form of abortion procedure. To prohibit the safest form of abortion procedure be an impermissible undue burden. And finally, Justice Breyer said that though the statute had as its intent just prohibiting one particular abortion procedure, it was written in such a vague manner as would prohibit almost all, or at least many, abortion procedures. Now, your 2 questions. The first is, what was Congress' authority to adopt the Partial Birth Abortion Act? I think that those on both sides of the aisle believe that Congress has this authority pursuant to the Commerce Clause. In fact, if you read the statute, it has a jurisdictional hook within it. But in addition, the Supreme Court said as recently as a year ago in Gonzalez versus Raich that producing a commodity that's sold in interstate commerce is inherently something to be regulated by Congress and the Commerce Clause Authority. Likewise, doctors who are providing a service that's bought and sold in interstate commerce can be regulated under the Commerce Clause Authority. Second, what's the Supreme Court likely to do, and what do I think they should do? I think this case is so important on many levels. I think it'll show whether the Roberts Court really cares about precedent and stare decisis. As I alluded to, there was so much discussion, much of it in the context of abortion, about precedent and super duper precedent. Well, Stenberg versus Carhart is right on point. It's 6 years ago. are Chief Justice Roberts and Justice Alito, for all the discussion of precedent, going to feel any need for fidelity to this decision? What about Justice Kennedy? What's his view with regard to precedent going to be? And Justice Kennedy wrote a vehement, even a vitriolic dissent in Stenberg versus Carhart. Now, let me say one thing about Justice Kennedy and then answer your final part of the question. Justice Kennedy has an interesting history on the Supreme Court with regard to abortion. When he first voted in an abortion case in Webster versus Reproductive Health Services in 1989, he joined Chief Justice Rehnquist and Justice White, the two dissenters in Roe versus Wade, which is a 7-2 decision, in essentially calling for the overruling of Roe. When abortion came back before the Supreme Court in Planned Parenthood versus Casey, we now know, thanks to Justice Blackmun's papers being publicly available, that Justice Kennedy voted to overrule Roe versus Wade. But sometime between the conference where he voted that way, when the decision was publicly released, Justice Kennedy changed his mind and voted as a fifth vote in a 5-4 decision to, quote, reaffirm the essential holding of Roe versus Wade. As Doug just pointed out in Stenberg versus Carhart, Justice Kennedy wrote a strong dissent, a vehement dissent, saying he never thought his vote in Casey would mean upholding this. What's he likely to do here? Now, you allude here to the fact that Congress said, as a matter of fact, that it believed that partial birth abortion was never in the health interest of the woman, so the law didn't need to provide a health exception. I don't think that's really a matter of fact-finding by Congress. I think it's Congress giving its opinion that it wants to have this law stand, so it says, we believe this is never in the health interest of the woman. The question is, will the Supreme Court say, as it did in Roe versus Wade, that it's for a woman and her doctor to decide what's in the health interest of the woman? Justice O'Connor wrote separately in Stenberg versus Carhart, say any partial birth abortion law has to have within the statute an exception for the health of the woman. Or will the court here defer to Congress, perhaps signaling a willingness to allow much more regulation of abortion? You ask my opinion. I hope with all my heart that the Supreme Court will affirm Stenberg versus Carhart and say that abortion should be left to the woman and her doctor to decide.
Let's try and find some common ground. In the religion area, you gave a very fine analysis of the Ocentro case, which of course was a statutory case, the application of RFRA in the federal context. The change in personnel on religion seems to me to be somewhat significant in the area of, or possibly significant in terms of the interpretation of the Free Exercise Clause. There was a significant disagreement between Antonin Scalia and Sandra O'Connor on the application of the Free Exercise Clause and whether or not a generally applicable neutral law could be subjected to strict scrutiny and require a compelling governmental interest. Justice O'Connor thought it could and should, and Justice Scalia, of course, in Smith says quite the opposite. With the departure of Justice O'Connor and the substitution of Justice Alito, who in his lower court rulings is significantly friendly to the free exercise of religion, do you think Smith is open for reconsideration?
I think you asked a great question. I read over 200 of Third Circuit Judge Alito's opinions, and the one area where he was less conservative than the Supreme Court was with regard to free exercise of religion. But I still can't count 5 votes on the current court that are likely to overrule Employment Division versus Smith. But perhaps there will be that, especially if Chief Justice Roberts is willing to take a position. I think the place in religion where we are going to see the change is the Establishment Clause, because I think here we now do have 5 votes, Roberts, Scalia, Kennedy, Thomas, and Alito, to allow much more government aid of religion, much more religious involvement in government, to overrule the test that's controlled the Establishment Clause since 1971.
7 commandments instead of 5?
I argued the Texas 10 Commandments case in the Supreme Court where I lost 5-4, so I have to admit there's some pain to the jokes and the subject associated with that. But if you remember, in McCreary County versus Kentucky, the other 10 cases where they struck it down, it was 5-4 to invalidate the Kentucky 10 Commandments display. The 5 were Stevens, Souter, Ginsburg, Breyer, and O'Connor. O'Connor being replaced by Alito here, I think is likely to make all the difference. And again, if you go back to Alito's Third Circuit decisions, he was very deferential to the government in the Establishment Clause area.
Thank you, Irwin.